interactive section organized by LawInternships. LawInternships provide internship opportunities in the field of law, primarily to the students pursuing undergraduate or postgraduate programs. Ms. Sanchita Srivastava, founder, LawInternships, and board members comprised of Mr. Amit Dubey, Mr. Parth Sharma, and Mr. Adyan Agarwal, along with their team of young, dynamic, and competent members, assist in providing opportunities for gaining professional experiences as well as improving legal skills while being enrolled in a full-time law program. The objective is to prepare students for the real world by imparting practical exposure and relevant skills through legal internships. We have amongst us Ms. Rupamti Salni ma'am. Ma'am is a managing partner of Rupamti Salni and Associates. She is an accredited civil as well as commercial mediator and also has been in legal profession since 2014. She has completed her graduation in BCom LLB Honours from Amity Law College and holds master's degree in international dispute resolution from Humboldt University, Berlin. Ma'am's core practices areas include arbitration and litigation of criminal, civil, and family, real estate, construction disputes, engineering disputes, and maritime disputes. She is also formally associated with the Chamber of Justice S.K. Mishra, former judge of Delhi High Court and sole arbitrator. We are honored to have you here, ma'am. If anyone has any queries or questions, you can raise your hand and we shall recognize you and unmute you. Also, you can put the questions in the chat box too. In the end, the floor shall also be open for any questions. Without delaying any further, let's begin the session for today. Over to you, ma'am.
Thank you, Tara. Thank you for a good introduction. I'm honored to be here and discussing with all of you the on arbitration clauses and agreements. Give me just 1 second. I have prepared a PPT and I would like to share that with you.
Sure, ma'am. Ma'am, do you want this to be an interactive section where the students will be asking questions in the midst of the presentation, or do you want this to be a Q&A section where they will be asking?
Last minute, sorry.
Oh, I think it would be better that we first take the topic and at the end, I can have the questions. You can ask me, people can write whatever, they can unmute themselves and they can write their questions or ask their questions.
Okay, sure, ma'am, sure.
Okay, so we can do it like that, and I don't know why I'm, okay, yeah. So. Okay. I think it's visible,
Yes, ma'am, it's visible.
Right. Okay, great. So good evening, everybody. I am Rupam, and I'm going to be talking about the getting around arbitration clause, lessons from domestic and international arbitration. Basically, we're going to discuss that how important the arbitration clause is, an arbitration agreement is, if you want to succeed in an arbitration proceeding, and what are the standard clauses that you need to know as a lawyer, and what are the elements, how important it is to know the elements so that your agreement or your clause is not, held invalid. So very quickly, we just we start with the arbitration itself. We all know that arbitration is a form of alternative dispute resolution process where, parties in a dispute refer it to one or more persons who are called arbitrators, who provides a decision known as an award that the parties have agreed to be legally bound under. And the Arbitration and Conciliation Act is the law governing the arbitration in India. Before we understand the arbitration clauses and agreements, let's first... I'm sorry, is there somebody talking to me? Can somebody let me know?
No, ma'am, you can continue.
Okay, I'm so sorry. So before we understand what is the arbitration clauses and agreements, let's first understand the domestic and international arbitration, because the clauses and the agreements have their different application part 1 and part 2 of the Act, as you must know. Now, according to section 2 subclause 7 of the Act, domestic arbitration is an arbitration which is held in India, whose outcome is an arbitral award under part 1 of the Arbitration Act. And whereas international commercial arbitration is an arbitration where at least one party is either a foreign national, a foreign government, a foreign company, or any subsidiary, not subsidiary actually, but the registered, the head office of a foreign company where the operations are held. And part 2 of the Arbitration Act is applicable to the international arbitrations. Now, part 1 and part 2 of the Act is very important. It is also important in construing the arbitration clauses. So now we come to the arbitration clause. What is an arbitration clause? If you can read the screen, section 7 of the Act defines the arbitration agreement, and it says that it should be a written agreement where parties have agreed to submit their disputes to arbitration. The parties can refer their disputes to arbitration either before the dispute arose or after the dispute arose. So anytime the parties can consent and they can agree to have their disputes referred to arbitration. Now that reference, the containing that reference in a document is actually an arbitration agreement. As per section 7 subclause 2 of the Act, an arbitration agreement may be in the form of an arbitration clause in a contract or a separate agreement. We all know that the arbitration agreement is separate from the main agreement. So either you can have one clause in your main agreement, or you can have an entire separate arbitration agreement which will actually govern your reference to arbitration. Then further, as per section 7 subclause 3 of the Act, an arbitration agreement must be in writing. This must is very important. Actually, it shall be in writing. So the shall is very important. Then subclause 4 basically says that an arbitration agreement is in writing if it is contained in, that means if it is in the form of a document signed by the parties, or it is an exchange of letter, telegrams, or other means of telecommunication, including communication through electronic means, which provides basically a record of the agreement. So that's how your arbitration agreement should be. Or it can also be an exchange of statement of claim and defense in which the existence of the agreement is alleged by one party and not denied by the other. Basically, if you have in this case, if you have a clause, if you have an arbitration clause, that can be exchanged in your pleadings and it should not be denied. In that case, you have a valid arbitration agreement. Now, besides for an arbitration agreement to be valid on the basis of what we just discussed, it must also satisfy the conditions specified in Section 10 of the Indian Contract Act. What does Section 10 say? That it obviously must be made by the free consent of the parties. The parties must be competent to contract. It must be a lawful consideration, and with a lawful object. The contract should be made with a lawful object. And last, obviously, that it should not be expressly declared as void under the Contract Act. So these are basically some of the points that have to be conditions that have to be taken in regard while in your arbitration agreement to have your arbitration agreement. Actually, these conditions are mandatory. Next comes the standard arbitration clause. Now, a standard or arbitration clause should okay, let's understand first what is standard. Why is it called a standard arbitration clause? In order to avoid the ambiguity with regard to the intention of the parties to arbitrate and to ensure that the parties derive maximum benefit of party autonomy, it is necessary that parties they adhere to guidelines and of a standard arbitration clause that is clear, that is unambiguous. So that it's very clear that the parties have their intention of referring their disputes to arbitration. So such a clear clause, drafting such a clear clause is very important. Now, what is this standard arbitration clause? It is a clause that includes the disputes which are referred. Basically, the clause we are now going to discuss the points that makes a clause as a standard clause. that makes a clause as a clear, good clause, like I would say. So it should have the disputes which are referred to for arbitration, that is the scope of issues, that breach, termination, force majeure, etc. These are the disputes the parties can agree that they want to refer to arbitration. So if you define your disputes in the agreement, it's clear. It's more clear for the tribunal or to then assume their jurisdiction. Then whether any arbitral institution is to administer the proceedings. If you want to have an ad hoc or an institutional, if you don't say anything in your agreement, it's deemed ad hoc. But if you mention about an institution like CAC, like LCIA, like ICC, that means you want an institutional arbitration. Now, if the intention of the parties is to have an institutional arbitration, in that case, they must put that in their, record that in their agreement, so that you do not waste any further time. Then comes the number of arbitrators, 1, 3, or 5. Language in which the proceedings, arbitral proceedings should be conducted. Generally, it's English, but the parties are free to decide their language, and obviously then they have to choose an arbitrator who's also well versed. Or sometimes what happens is the parties choose a language, but the arbitrator decides that no, this language is not known to the tribunal. So the tribunal gives an order that the language should be English and all documents should be translated into English. Then very important is the place, venue of arbitration. If you have studied arbitration a bit, or if you follow arbitration judgments a bit, you would know that a lot of dispute, a lot of judgments, a lot of commotion is on this part of the contract of the agreement. Parties need to, very carefully choose their words as references to whether they're saying, referring it to a venue, or whether they're referring to the place. Because if you are referring it as a venue, that means that only physical hearings are going to take place at that venue. But if you are referring it to as the place of arbitration, that means you are choosing the seat of arbitration. And the seat of arbitration has the courts of that seat, the local courts of that seat have the power to give interim measures and to give, allow the appointment of arbitrator. They basically have the first authority over the matter. So it's very important to specifically mention whether it's the place of arbitration or it's the venue of arbitration. Venue can be anything. Seat or place of arbitration is the place where the award has to be passed. So that must be kept in mind. Then comes the governing law of arbitration clause. Again, a very important point, that substantive law and procedural law. A proceeding is divided into two types. You have to have substantive law that decides the merits of your dispute, and procedural law that defines the procedure that should be followed to conduct the arbitral proceedings. So the arbitration clause itself is generally understood to be a separate from the underlying contract. It has its own governing law, which may differ from the law of the main agreement. So if the main agreement is governed by, let's say, English law, it's possible that the arbitration agreement is governed by the Indian law, because it's separate by the virtue of doctrine of separability. For example, issues relating to substantive validity, scope, meaning of arbitration agreement, they are all governed by the proper law of the arbitration agreement. And by proper law, we always mean the substantive law. So the parties shall, if possible, mention in their arbitration agreement, in their arbitration clause, as to what is the governing law of the contract, what is the governing law of the arbitration agreement. Then comes the seat of arbitration. The choice of the seat of arbitration brings with it the supervisory jurisdiction of the local courts, like I just told you. The local laws to govern the arbitration proceedings. Those courts are likely to be the first and exclusive authority to decide on matters such as granting interim measures, then rules safeguarding the due process of arbitration proceedings, including standards of fairness and impartiality of the arbitrators, or removal or disqualification of arbitrators, enforcing the arbitration agreement. For example, does the arbitration agreement have to be in particular form in writing or not? Who's going to decide that? The courts having the jurisdiction, the seat of the court at the seat of the arbitration. Then obviously the challenge and enforcement of award. also depends on the seat that you have chosen, and issues of arbitrability is also determined by the courts having jurisdiction over it. So that is why it is very important that you have these particular 5-6 points in your arbitration clause to make it clear, to not have it disputed. So this is a very important point. Next, I am going to take this case of XMEC Pharmaceuticals versus Alchem Laboratories Limited. Basically, what had happened in this case that they had a very ambiguous clause. Now, we are going to read this Article 13, if everyone can focus on the screen. Article 13, now this is an excerpt from their arbitration agreement. Okay, this is the clause that was there in their agreement. The Article 13 says proper law. It says the proper law of this agreement is the law of the UK, and the parties submit to the exclusive jurisdiction of the courts of the UK and of all courts having jurisdiction in appeal from the courts of the UK. Okay, this is the court jurisdiction. Then they have another Article 14 called as arbitration, in which they read as all disputes and differences whatsoever which will at any time hereafter arise between the parties in relation to this agreement, which the parties using their best endeavors in good faith cannot resolve, shall be referred to arbitration before any legal proceedings are initiated. The arbitration shall be conducted in UK in accordance with the provisions of the law in UK in effect at the time of arbitration, and shall be conducted by one or more arbitrators appointed there under. Now, this is a very terrible clause. It's a very terrible arbitration clause because it simultaneously provides for two things. One, it says exclusive jurisdiction of the courts, and at the next point, it says arbitration. Now, both are inherently contradicting to each other. You know, therefore, this is why it becomes very important to have clearly drafted your arbitration clause. Now, in this particular case, it was so difficult for the courts to interpret whether the parties wanted arbitration or whether they wanted a court jurisdiction. And it took so much time for the courts to decide this. It happens a lot of time in domestic arbitration in India that parties have such unclear arbitration clause that before the proceedings could begin, the matter is pending before the courts for years, just on the basis, on the point of interpretation of this agreement and of this clause, whether it is a valid clause or whether it's an invalid clause. We are going to discuss the validity of clause later on. But the point here to make is that it's very important that your arbitration clause is clear. So tomorrow, if you have a client coming up to have an arbitration, make sure, or if you're drafting contracts, agreements for your clients, make sure that you draft a very clear arbitration clause, because that otherwise will bring you trouble if the dispute arises. Then let's see, how are the standard clauses? Now, okay, if you will open the institutional websites, you will find that all institutions have their own arbitration clause, and they have their own standard clauses. You can, the unsettled model law has the clauses, all institutions have their clauses. So yes, you can always pick up those clauses and you can always put them, retract them in your agreement. Otherwise, that's how a standard arbitration clause looks like. Okay, it has everything. It has the disputes that the parties want to refer to the arbitration. Then it has the place of arbitration mentioned. It has how many arbitrators should be there. Then it also has the condition that when the courts cannot exercise their jurisdiction. So it clearly mentions about all of this. So this type of clause will not make it difficult for either the courts to refer disputes to arbitration or even the arbitral tribunal to assume jurisdiction in case it's challenged under section 16. So it's always better to have such clear clause in your agreement. Similarly, it's for the international commercial contract. It's a bit detailed because points like language becomes important. Because if you have parties from different nationality, then which language to adopt? That's, if you have that in your agreement, your clause, it's very important. It's very good. Then obviously the rules, the procedural rules, the place of arbitration, number of arbitrators, and you will see the points that we just discussed under the standard clause. These are the all points that have been mentioned in this in this clause, it's very clear. And it also says that the judgment upon the award rendered by the arbitrator may be entered in any court having jurisdiction thereof. So that is for the setting aside. That in international arbitrations, it becomes important to know that, whether which court will have jurisdiction, because the seat can be some else and venue can be something else. In domestic arbitrations, generally two things are assumed: that the language, unless parties have otherwise agreed to some other language, it will be English, and the substantive law will be CPC and evidence. However, the tribunal is not bound to follow it, but that's how the practice is generally. Now we come to elements of an arbitration clause. We just did what does a standard clause contain. Now we come to the elements that if we've just read the arbitration clause and we've seen that language, place, parties consent to refer disputes to arbitration. These are all elements. So what are the important elements that constitutes an arbitration clause? Now, one is consent. Arbitration cannot happen without the consent of the parties. Parties clearly note that in the event of a dispute between them, they would not go to the court. Instead, they will proceed to arbitrate their dispute, and that shall be binding on them. So this kind of consent is very important. Unless the agreement records such a consent, the courts cannot refer the dispute to arbitration. Then comes the presiding authority. Now, the presiding authority is known as the arbitrator, who is in charge of deciding the disputes between the parties. One of the key features of an arbitrator, in fact, is that the parties are free to choose their presiding authority, who is going to be the arbitrator. So what is going to be the panel of arbitration? That becomes very important. In clauses, I have come across in practice that there are clauses where parties also in their arbitration, where they have separate arbitration agreement, they also record the procedure for appointing the tribunal. So that's a very brilliant idea, because you just, by doing this, you stop the court interference. You minimize the court interference by having as much clear agreement as possible. Next is the seat of arbitration. The seat of arbitration basically determines the courts which would exercise jurisdiction over the arbitration proceeding. We just discussed that. In absence of such an agreement, the our Arbitration and Conciliation Act 96, 2019 amendment, it solely operates within the territory of India. So if there is no seat mentioned and it's a domestic arbitration, it is assumed that the seat is India. Venue can be anywhere in India. So when there are clauses which say that the venue of arbitration is Mumbai and the seat is India, or it says the place of arbitration is New Delhi. So it means that the Indian law is going to be the substantive law and the procedural law governing the dispute, but the award needs to be signed at New Delhi, because the courts at New Delhi will assume jurisdiction first. They will have the first jurisdiction. So that's the important, seat is a very important element of a clause. And next is obviously the party autonomy and procedure. Basically, arbitration gives the parties, the choice to select applicable laws, especially if it's a commercial arbitration. Parties can choose that they want to be, the procedure shall be governed by the ICC rules, and the merits of the dispute can be governed by the French law, the Singaporean law, the Hong Kong law. So the parties are free to do that, absolutely. Then there is enormous flexibility to choose the procedure that shall be applicable. The rules of arbitration can either be self-governed, however, that rules have to be in the spirit of the public interest of India if it's a domestic arbitration, or if the seat of arbitration is India. In that case, the rules cannot be such which are against the public interest of India. Otherwise, you can challenge the award on such grounds. Last is the finality of outcome. The award shall be binding the parties who have referred the dispute to arbitration. Lot of clauses do not have the finality of outcome element in it, but it's very important that the parties, although it's always assumed that it's deemed under the law that the award is final and binding. That's one of the main features of arbitration. But there are clauses where parties record this in writing, and I think it's very important if you do that. There's no harm. So these are the important elements that are important elements of an arbitration clause. So you always have to make sure that your arbitration clause bespokes all, contains all these elements, so that your clause cannot be disputed, by the respondent. Now we come to the validity of arbitration agreements. Till now we've studied that arbitration, how you draft an arbitration agreement, what does an arbitration agreement mean, what does it contain. Now we have the arbitration agreement in place. Now we are referring the disputes to arbitration. What happens when the matter is moved before the court? The court only has the power now to check one thing, which is the validity of arbitration agreement. If the court thinks the arbitration agreement is valid, it refers the dispute to arbitration. Now, a clause in a contract can be considered as valid arbitration agreement only if an agreement to refer disputes or differences to arbitration is expressly or impliedly spelled out from the clause. If the parties have expressly or impliedly mentioned, spelled out, signed, agreed that they want to refer their dispute to arbitration, if it's clear, then it's a valid arbitration, agreement. The arbitration clause or agreement will still be valid if the main contract is null void or incapable of performance. This is by the virtue of doctrine of separability, which makes the arbitration agreement separate from the main agreement. And for the validity of an arbitral clause, it's very important that the intention of the parties to enter into an arbitration agreement have to be gathered from the terms of the agreement. So, when your clause should be drafted in such a way that the intention of the parties to refer to arbitration should come out should be interpreted from the terms of the agreement itself. If the agreement only provides that there is a mere possibility of the parties agreeing to arbitration in the future, instead of an obligation to refer disputes to arbitration, then this is not a valid and binding arbitration agreement. An agreement which is only or an arbitration clause which only talks about referring the disputes to arbitration in future, if the disputes arise, in that case, that's not considered as a valid arbitration agreement. On the contrary, if the clause is drafted in such a way that parties, have clearly spelled out their intention that any dispute that has arisen should be referred to the courts. That can be that is held to be a valid arbitration ground. Then, so this is a very a landmark judgment, KK Modi versus KN Modi, and Bharat Bhushan Bansal versus UP Small Industries Corporation. The Supreme Court held that a clause in a contract can be considered as valid arbitration agreement only if an agreement to refer disputes to arbitration is expressly or impliedly spelled out from the clause. Then there are various interpretations for holding an arbitration agreement valid. This was a very important judgment in this matter. What does it say? It spells out that what are the points that needs to be kept in mind to have your arbitration clause or agreement held valid. Now, where the clause provides that in the event of disputes arising between the parties, the disputes shall be referred to arbitration, mandatory for courts to refer it to arbitration, it's a valid arbitration agreement. But where the clause relating to settlement of dispute contains word which specifically exclude any of the elements of arbitration agreement or contains anything that detracts from an arbitration agreement, it will not be an arbitration agreement. Now, for example, if you remember the Article 13 in the XMEC case that we studied, it specifically talks about court jurisdiction. It detracts from arbitration. That clause cannot be held to be a valid clause. And if it's not a valid clause, you will not be referred to arbitration. So, the mere use of the word arbitration or arbitrator in a clause will not make it an arbitration agreement. The elements of arbitration agreement and the should be there. The should have presence to be to have your arbitration agreement declared as valid. The fresh consent of the parties for reference to arbitration, that will not make the arbitration agreement valid. If you have to have the fresh consent again to your arbitration agreement is drafted in a way where it says that if the dispute arises, you will first have to freshly take consent of both the parties to enter into to refer disputes to arbitration. In that case, that's not a valid arbitration clause. For example, if you use the words such as, if you have read the clauses where there are phrases like parties can, if they so desire, refer their disputes to arbitration. Or another example, if I can give you of such a clause, would be in the event of any dispute, the parties may also agree to refer the same to arbitration. Or if any dispute arise between the parties, they shall consider settlement by arbitration. All this, they indicate that the clause is not intended to be an arbitration agreement. In this, you cannot make out that the intention of the parties is to refer this particular dispute to arbitration. It says in the future the parties can do that. So that is not valid. That's not considered as a valid clause agreement. Now, such clauses basically indicate only a desire, or a hope to have the dispute settled by arbitration, or a tentative arrangement, if you can say, to explore arbitration as a mode of settlement, if when the dispute arises. Such clauses require the party to arrive at a further agreement to go to arbitration. They are already not agreed. Right now, they've only taken it as an option. So any agreement or clause in an agreement requiring or contemplating a further consent before a reference to arbitration, that is not an arbitration agreement. And the law on it is very clear in the matter of Jagdish Chandar versus Ramesh Chandar. The Supreme Court has very clearly laid down this law. Any future reference, any future consent, fresh consent, then it's not an arbitration agreement. Next, okay. Ambiguity in arbitration clause. Now, we've studied, we've known that ambiguous arbitration clauses, what are those, and they have a lot of problem. But what basically ambiguity means? There are instances where arbitration clauses are very poorly drafted and they do not cover the extent of arbitrable disputes, or are unclear with regard to the intent of the parties to arbitrate, or the seat venue place of arbitration is unclear. That is called as an ambiguous clause. That means there is no clarity as to the seat, venue, or place, or there is no clarity as to the number of arbitrators. There's no clarity as to the law that will govern the dispute. So these are ambiguous clauses. Most common case of an ambiguous arbitration clause is when the parties do not express clearly that in case of a conflict, the method to use in order to settle the disagreements will be arbitration. That's the most ambiguous, because even the intention to refer it to arbitration is not clearly spelled out. Since the general rule is that the arbitration is prompted out of a contract, if there is not an explicit arbitration clause within the contract, it would not be an agreement to arbitrate. So it is in the interest of the parties always to draft an arbitration agreement or an arbitration clause that is not narrow or unclear about their intention. I'm so sorry, I just have water. Sorry. So the party should always make an endeavor to draft an arbitration clause or agreement that is wider enough, that contains as much elements as possible. Otherwise, it becomes very difficult for the courts to even interpret whether or not they should refer it to arbitration or not. So this is an example of an ambiguous arbitration clause. It says that every dispute of any kind or nature shall be submitted to arbitration unless it is a technical dispute which shall be resolved by a technical expert appointed by the party. Now, you see, if you read it, it's very ambiguous. Why? Because the clause has a lot of flaws. Who determines whether it is a technical dispute? How shall a technical expert be selected? What if the parties cannot agree upon a technical expert? Then, shall the technical expert resolve the dispute by means of binding arbitration? All of this becomes very, very ambiguous. These flaws such an agreement cannot be held valid at all. Now, I just want to ask the moderator that if I write it on the chat, can all the attendees have a look at it? Is there anything kind of a hi? Sorry, the moderator Tara.
Yes, ma'am.
Yeah, can I write on the chat where the party, where all these attendees can have a look? I wanted to basically give an example of an ambiguous clause. So, is there any such provision?
1 minute, ma'am.
Can I?
Sure, ma'am, sure. Just give me 30 seconds.
Of course, yes. Please take your time. Okay, I think I don't see such an option here. I'll just very slowly read for you guys the uh, clause, again a type of clause where you can point out the flaws. It says any dispute under this agreement shall be settled by binding arbitration unless any third party is materially necessary to the resolution of the dispute. Then the arbitration shall not be so mandatory unless the third party agrees unconditionally to participate. Now, a very third class clause. Why? Because it doesn't contain a single element that we have studied about an arbitration clause. It talks about, the flaws are so inherent in such type of a clause, so unclear, because who decides if a third party is materially necessary or agreed unconditionally to participate? How can we talk about a third party in a clause? So, this is not kind of a mandatory thing. If the parties disagree as to whether the third party is materially necessary or materially not necessary, or they refuse to participate, then will the court intervention be required? So these kinds of clauses bring so many questions that it's very difficult to interpret them. And this particular clause does not talk about place, language, seat, intention of the parties, nothing. So it's a very, very flawed clause, and it's very ambiguous, and most likely to be held invalid. What happens is, when the clause is ambiguous, a lot of time the courts make an endeavor to interpret it and to give it some meaning, so that the intention of the parties is well taken care of. If the intention of the parties is clear that they wanted arbitration, but the clause is not very well defined, the courts make it an endeavor, the tribunal makes an endeavor to interpret it as much possible, constructively, to give it a meaning. Presently, the Indian courts are also of the conclusive view that an arbitration agreement is to follow the well-settled principles we just discussed in the Jagdish Chandra case, whereby the specific and direct intention or expression of the parties to refer to arbitration proceedings are clear and precise from the language and terms of the clause in the agreement. The courts have very well settled law on this, that the intention of the parties should be very, very clearly spelled out if they want arbitration as a dispute resolution mode. Any agreement or a clause requiring or contemplating a further consent, like we discussed, is not an arbitration agreement. So, now these are the landmark judgments, very good judgments. I've just made this slide so that you guys can note down and read it in your free time, because these judgments are basically on the ambiguity of jurisdiction, the clauses which have the ambiguous clauses where the jurisdiction of the court is not decipherable. What happens is, in practice, most of the time, the disputes that come out of ambiguous clauses are which courts has power, which courts exercise the jurisdiction, where, because there is no seat defined, what will be the seat, what will be the venue. Very common types of cases before the court. Now, these are 4 landmark judgments which have very clearly, they have either included or excluded the jurisdiction of the Indian courts. So there were ambiguous arbitration clauses, and then the courts have interpreted and given it a meaning. Now, in the citation Infowares versus Equinox Corporation, the Supreme Court held that an agreement to resolve disputes using Californian law, that was the substantive law chosen by the parties, would not be an implied exclusion of provisions of Part 1 of the Act. So he appointed an Indian Chief Justice to resolve the matter, but according to the Californian law. Similarly, in Dosco India Private Limited versus Dusan Infra Corp, the Supreme Court held that an agreement to resolve disputes in South Korea under Korean law would operate as an implied exclusion. The seat is South Korean, the law is Korean law. It's a part two of the part two of the act will be applicable. Part one is not. And the arbitration petition seeking an order of appointment of an arbitrator would not be maintainable in Indian law, Indian courts. It would be then maintainable before the Korean courts. So then in Videocon, okay, this is a very good judgment if you want to have a good reading for arbitration. Videocon Industries Limited versus Union of India, a very landmark judgment. You know, in this the agreement was governed by the law of India. The venue of arbitration was agreed to be Kuala Lumpur, Malaysia. So the parties had agreed that the arbitration agreement would be governed by the laws of the England. So they had all mixed. They had the law governing the main agreement as Indian law, the law governing the arbitration agreement as English law, and the venue of the arbitration as Kuala Lumpur. In that case, the Supreme Court again held that it means that it has implied the exclusion of Part 1 of the Act. So similarly, Yogaraj case, the court held that once the parties had agreed to arbitrate under the Singapore International Arbitration Center rules with the seat of arbitration in Singapore, Part 1 of the Act would stand excluded. So this is basically all about ambiguous clauses. Ambiguous clauses, they're very important part to understand, because sometimes when we as lawyers we are drafting these clauses, we kind of make it ambiguous ourselves. So if we keep it in mind, the elements of an arbitration clause, the standard clauses, you know, the points that a standard clauses contain, we can never have an ambiguous clause, and you save a lot of time while having an unambiguous clause. Always remember that. What are the downfalls of having an ambiguous arbitration clause? You know, a well-constructed dispute resolution clause is actually the foundation of a cost-effective, efficient dispute resolution process, because you diminish the court interference, the time. But a lot of times, you know, the courts most of the time the courts are faced with the, you know, arbitration clauses that are problematic in some aspects or the others. Now, these clauses have defects in them. The process becomes inherently flawed. What happens in case of an ambiguous clauses? The process becomes flawed, and it becomes to some court intervention and delay, because the tribunal cannot assume jurisdiction. If the clause is not clear, then it goes to the court. The court takes its own time to interpret the clause. Then ambiguity concerning the intent or scope can delay resolution and hamper the enforcement of the award. Obviously, again, it takes time for the court to come to a conclusion, to give it a clear meaning. And that also an ambiguous clause can always hamper the enforcement, because the award can be challenged. Then the agreement cannot be executed in accordance with the intention of the parties. Now, this is very important, because like I told you, intention of the parties must be explicitly spelled out in a clause. That's the importance of having a clear arbitration clause. Now, if it's an ambiguous clause, then the intention of the parties is not clear. Now, for example, a situation where the agreed arbitral institution cannot fulfill the arbitration procedure in accordance with the requirements of the applicable law. Now, that's the problem that comes when you have an ambiguous clause. You do not have clearly written the institution. So the institution that you have mentioned is wrong. In that case, none of the institution can actually adhere to the procedure according to the intention of the parties. Sometimes names of two or more institutions are similar to the name indicated by the parties. You know, they have indicated a random name called as International Court of, let's say International Chambers of London. So that there is no such institution called International Chambers of London. So now there is a ambiguity over here as to whether they're talking about the institution of London or ICC. So such deficiency can also be never corrected, because it takes, if the court there are one or two cases where the courts have in English courts have interpreted such a reference of such mixed arbitral institution as choosing one arbitration institution on the basis of the location, but it's very difficult to correct such deficiencies by the court. When the parties have not specifically stated the seat of arbitration but have indicated a place or venue, the courts may infer such a clause to indicate the seat of arbitration and infer supervisory jurisdiction of a court over the proceedings, which can be contradictory to the intention of the party, because they have not mentioned it separately, whether it's a seat or whether it's a venue, whether it's a place. So, that is very important. Now, such ambiguity in arbitration clauses leads to parties depriving themselves of an ability to settle disputes by arbitration. Uh, Obviously, this becomes very, this gets you additional financial cost and long-term litigation in the local courts, because only the courts have the power to give a meaning to the ambiguous clauses. So this leads to the parties actually depriving themselves of settling the dispute by arbitration, because sometimes if the clause is unable to be interpreted or given a constructive meaning, then the parties will not, the dispute will not be referred to arbitration. The parties have to take a course of the court. So that way the intention of the parties can be lost. Okay. Then, that's more or less about the ambiguous clauses. Obviously, I'll conclude by saying that a well-constructed dispute resolution clause is the foundation of a cost-effective. We all understood that. There are courts are regularly faced with such clauses, and they regularly try to interpret and give it a constructive meaning. But so that the objectives of ADR mechanism is not lost, then ambiguity in arbitration clauses leads to parties depriving themselves because okay, it is necessary and in the interest of the parties to conform to standard guidelines while drafting clauses, whether in the case of domestic arbitration or international commercial arbitration. Can the moderator please this woman to speak by?
Who it is, kindly unmute yourself. Kindly mute yourself. Let me check.
അപ്പൊ അവള് പഠിക്കുന്നുമില്ല ഇത് നോക്കുന്നില്ല പിന്നെ അവൾ എന്തോ എടുക്കുക
Can you mute her?
Yes, ma'am.
Are you?
Yes, ma'am. Yes, ma'am.
നോട്ടല്ലേ നീ ഒന്ന് വെറുതെ സംസാരിച്ചു
Okay, I don't know. Anyway, just kind of come to the conclusion.
അവള് കുത്തിന്ന് പഠിക്കണമെന്നെങ്കിലും അവൾക്ക് മാർക്ക് ഉണ്ടായിരുന്നെങ്കിൽ വിചാരിക്കാം ഇതൊക്കെ മാർക്കും കുറവാണല്ലോ പിന്നെ വേറെ ആരാ
Can you please mute her?
3 പേരേ ഉള്ളൂ ഇങ്ങോട്ട് 3 ഗേൾസും ബാക്കിയുള്ള ബോയ്സ് 3 എണ്ണത്തിൽ ഒരെണ്ണം നീ
Ma'am?
Yeah, now I think she's muted. Thank you so much. Anyway, so
continue.
It's okay. Basically, so that makes us come to the end of talking about the arbitration clauses. That just a small recap: the standard drafting of the clause should contain obviously it should adhere to section 10 ingredients, and it should have all the points that we discussed. The elements of arbitration clauses is very important, because that decides the validity of your clause. And if your clause is a well constructed dispute resolution clause, in that case your arbitration can be faster, and you minimize the court interference. That is the main objective of resorting to arbitration. So cost is less, time is less, efficiency is more. It makes it more feasible for the tribunals, where in a case where under section 16 the jurisdiction is challenged, in the arbitrator is in a better position to interpret the clause. So, as lawyers, it's very important that you keep it in mind while you are drafting contracts and clauses for your clients to make sure that your agreements are very well drafted. You know, your clauses are very well drafted and they adhere to the standard clause and they adhere to the elements. That's all for today. And if you guys have any questions or queries, you can always contact me over LinkedIn or you can drop me an email. Feedback is most welcome. Do let me know if you have any feedback for this webinar and any query. I think we'll just open for some questions and now we'll take those questions. Thank you so much for being so patient and listening to me. I hope it was a clear session to you. You guys did understand it.
Yes, ma'am. Sure, ma'am. Ma'am, am I audible and visible?
Yeah, you are.
If anyone has any queries or questions, you can raise your hand and we shall recognize you and unmute you. Or you can put the questions in the chat box. And now the floor is open for any questions. Ma'am, we have a few queries.
Yeah.
The first one is that if you had to pick one skill that is the most important to have as an arbitrator, what would you say it is?
I'm sorry, you asked me for a skill, right? If I heard you correctly.
One skill
Okay.
that is more important.
One skill as an arbitrator, I would definitely say that if you have chosen your law, you're clear about the seat of arbitration or you're clear about the substantive law that you've chosen, make sure that the arbitrator that you're choosing is aware of that law, is aware of the expertise that your dispute requires. That's the most important part. And what happens practically is the parties are generally, at least in India, the parties in domestic arbitrations, the parties are just running after retired judges to adjudicate their disputes, to arbitrate their disputes, but they fail that sometimes that retired judge or an arbitrator is not, known with the expertise side of the law or of the dispute that is required in your case. So make sure that the arbitrator that you choose has a good understanding of the expertise or the law needed for your case.
Sure, ma'am. Ma'am, we have another query. Why do you think arbitration is an important part of law?
Important part of law?
No.
Oh, well, it's a very different question, although it's not an important, I won't say it's an important part of law because it's a separate law in itself. And arbitration is important for various reasons. It's, I think important actually is not the right word in my opinion. I would say that it's an alternative in the law, and that alternative can be very important if the intention of the parties is clear, because then you have lesser time to choose to have your dispute resolved. If you go under fast track arbitrations, you can always have your matter resolved within 6 months. In none of the courts you can have that, none of the tribunals you can have that. Then if you have the authority to choose your own judge, you have the authority to choose your own arbitrator, you can never have that before the court. So these are the certain points. And then party autonomy, the biggest advantage. Party autonomy is that you as a party are free to choose anything for your dispute. These are the things that make arbitration very lucrative, as compared to litigation. So that makes it a very important part. And at the same time today, where especially in international disputes where a huge amount is concerned, where the parties are big shots, where there are big companies, where there are complex disputes, if you go before the court, you will have to be very the dispute will only be stuck on the ground. Which court will have jurisdiction in case of an international dispute? Which court shall be the one having power? But in an arbitration, you can have an arbitral tribunal anywhere from any part of the world, and he can decide your dispute. So that kind of, if your clause is clearly drafted, then you can have an arbitration and you can get done with it. You don't have to visit 3 different courts.
Yes, sure, ma'am. Ma'am, we have another query. Any tips for law students who wants to take up arbitration?
See, it's arbitration is a very interesting field. I would say that it requires, but it requires you to be thorough with the latest judgments that have come in, because what happens is that if you are dealing with a domestic arbitration, more or less you're always dealing with CPC. So yes, procedural law, you should be very good at evidence in CPC. If you have a good hand at CPC, whether it's arbitration or it's not, you will always be a successful lawyer. So procedural laws are very important to have your best hand at. And when it comes to arbitration, you should know that you should read more and more judgments and see how the law is constantly changing, because our arbitration act has been constantly amending from time to time, keeping in mind the trend that the parties adopt. So in arbitration, that becomes very important to know your the why are you going to arbitration, why are you going for arbitration, then that object should not be lost. So to keep that object in mind, you should always have your best hand at reading the latest law, the latest amendment. That's one thing very helpful if you want to pursue your career in arbitration. You should have a good command in procedure, and you should be well aware of whether to give your client whether to advise your client to go for institutional arbitration or ad hoc arbitrations. For that, you need to be very well aware. So read the law, read the act, read the amendments coming up, read the judgments. And yes, that's the only way that you can excel in arbitration, nothing else.
Yes, ma'am. These are such excellent tips for all the law students. And that's it. We are winding up with the queries. I would like to express the vote of thanks. Shall I, ma'am?
Of course.
I, Tara John, on behalf of Team Law Internships, would like to extend my heartfelt gratitude to Ms. Rupandi Sahni ma'am for taking out time from her busy schedule and interacting with the young minds. It was truly an enriching section. Thank you, ma'am.
Thank you so much, Tara, for such kind words. And thank you everybody to be participating here. And yeah, if you still have any queries or anything, you can always contact me.
Sure, ma'am. Sure.
All right. Bye,
Bye.
everybody. Bye. Good evening.
Thank you, ma'am.